Yo, what's going on? It's your boy Dev Hot, Title 4D University, your coach, teacher, and professor. And today we're going to talk about child support in reference to credit. And we're actually going to talk about credit in general, how you can have a clean credit report if you do things right. Now, how many of you have received some type of notice or indication that child support is currently reporting on your credit? I know a lot of you have, because when I was on child support, I received a notice, and I wasn't on child support for 2 months before they actually decided that they were going to furnish child support to my credit. But what is the big deal and the reason that you can get child support off of your credit? I know many of you may have even went to credit repair agencies and they were able to remove so many things from your credit, but child support just wasn't one of them. I'm here to let you know that I have a solution for you, and if you just stay tapped in, if you stay tuned in, you will get all the information that's necessary. If you apply these actions, then you'll be able to get child support off your credit, and you can just clean your credit up in general. So stick around. All right, guys, so what I want you to do is, number one, if you haven't already, I need you to go ahead and subscribe to my YouTube channel. Make sure you hit that notification bell and leave some type of message if you think this information is helpful or not. So the first thing that I want to refer to is what premises or what bases are given when it comes down to things being allowed to be on your credit or not, because there's rules to the game. There's rules to everything that we do, and if any agency, if any debt furnisher or credit furnisher, however you want to call them, if they are not adhering to the rules, the laws that were passed under the FCRA, which is the Fair Credit Reporting Act, then you need to do whatever in your power to call them out on the fact that they're not following the policy and the rules. So what I'm currently going to be doing is reading from a notice that was put out by TransUnion. I like to always go to the source of things so that this is not hearsay. These are things that you can actually look up yourself. I'm going to consolidate these things, make it a little bit easier for you so that you can be able to take this information and apply it immediately. All right. So notice to furnishers of information. Obligations of furnishers under the FCRA. The Federal Fair Credit Reporting Act 15 USC 1681 through 1681Y imposes responsibilities on all persons who furnish information to the Consumer Reporting Agency. These responsibilities found in Section 623 of the FCRA, 15 USC 1681 S2. State law may impose additional requirements on furnishers. All furnishers of information to the credit reporting agencies should become familiar with the applicable laws and may want to consult with their counsel to ensure that they are in compliance. The text of the FCRA is available at their website of the Consumer Financial Protection Bureau, which is www.consumerfinance.gov/learn-more. And then you'll get a list of the sections of the FCRA cross-references of the United States codes. So let's try to break this down a little bit. Now, mind you, I'm going to be reading directly from TransUnion. So I know a lot of the times they're going to be using jargon or language that we don't necessarily understand, even though it's English. But it's important that you try to gather and find as much understanding as possible. So when you don't understand certain words, literally, you should just go and look it up. These things will actually make you better with your comprehension of the things that you're reading, and it makes sure it assures you that what you're doing is the right thing or the correct thing. So if you go to Section 623 of the FCRA, it imposes the following duties upon the furnisher. So just real quick, who is the furnisher? The furnisher is the company who decides that they want to add something to your credit report. So TransUnion, Equifax, and Experian are the three major credit agencies, but they are not the furnisher. The furnisher would be somebody like child support, or the furnisher would be your credit card company, your mortgage company, your car note, whoever you make your car note payments to. These are the furnishers. So there's an accuracy guideline. The Fair Credit Reporting Act requires furnishers to comply with federal regulation dealing with the accuracy of information provided to the credit reporting agencies by furnishers. Okay, this is the general prohibition of reporting inaccurate information. The FCRA prohibits information furnishers from providing information to a credit reporting agency that they know or have the reasonable cause to believe is inaccurate. However, the furnisher is not subject to this general prohibition if it clearly and conspicuously specifies an address to which consumers may write to notify the furnisher that certain information is inaccurate. So at the end of the day, all information that's on your credit report, doesn't matter who it's coming from, must be accurate. What does that mean? That means if they list a certain amount on there, hypothetically, they say that you are in debt $50,000, and in fact you're in debt $49,999. That's incorrect. They have to actually put what is correct on the credit report. If it's not put on the credit report correctly, then what they have just furnished to you is called inaccurate. And under the Fair Credit Reporting Act, if the information is inaccurate, it must be removed from the credit report. Okay, so here is the duty to correct and update information. If at any time a person who regularly and in ordinary course of business furnishes information to one or more of the credit reporting agencies, determines that the information provided is not complete or accurate, the furnisher must provide complete and accurate information to the FCRA, which is the credit reporting agency. In addition, the furnisher must notify all CRAs that receive the information of any corrections and must thereafter report only the complete and accurate information. Once again, if that information is not correct, they already have a duty themselves to correct this information. But once you call them out on it, we're not even asking them to correct it. We're saying because you didn't make sure that this information was not correct, it must now be removed. A lot of the reasons that people are able to get so many things removed from their credit report is because of inaccuracies. So as a credit repair specialist and as someone who's been helping people with repairing their credit for the past 6 to 7 years, the inaccuracies is the number one thing that we use to be able to get these things off of your credit report. Okay, so now I'm going to move over to another notice that came from TransUnion. And this notice is the obligations of all users of the consumer reports. Okay, now users must have what's called permissible purpose. Congress has limited the use of a consumer reports to protect consumers' privacy. All users must have permissible purpose under the FCRA to obtain a consumer report. Section 604 contains a list of permissible purposes under the law. Now let's just break this down really quick before I move any further. As you can see, Congress has said that, listen, we got to protect the consumer. We got to protect their privacy. So in order to protect their privacy, anybody who's using the credit reporting agencies to report things and or to go and look at your credit report, they must have permissible purpose. So this will count for if someone wants to run your credit, they must have that written permission, that permissible purpose from you. If anyone wants to report anything to your credit, I mean anything, they must have that written permission, okay? They must have permissible purpose. So here's a list of what the law says permissible purpose is, okay? As ordered by a court or federal grand jury, subpoena, as instructed by the consumer in writing, as instructed by the consumer in writing, okay? You can find that in section 604A2. For the extension of credit as a result of an application from a consumer or the review or collection of a consumer's account. That's under Section 604A3A. For employment purposes, including hiring, promotion, decisions where the consumer has given written permission, Section 604A3B and Section 604B. For the underwriting of insurance as a result of an application from a consumer, Section 604A3C, where there is a legitimate business need in connection with a business transaction that was initiated by the consumer, or to review a consumer's account to determine whether the consumer continues to meet the terms of the account, to determine a consumer's eligibility for a license or other benefit granted by a governmental instrumentally required by law, to consider an applicant's financial responsibility status, for use by a potential investor or servicer or current insurer in a valuation of assessment of the credit or prepayment risk associated with an existing credit obligation, for use by state or local officials in connection with the determination of child support payments or modification and enforcement thereof. Let me read that last one again for those who are on here for the child support part of it. Permissible purpose is for use by state or local officials in connection with the determination of child support payments or modification and enforcement thereof, Section 604A4 and Section 604A5. Now, granted, I can go on and on and on, but I'm going to give you a couple more, just some highlights. The user must provide certifications. So according to Section 604F, it prohibits any person from obtaining a consumer report from a consumer reporting agency unless the person has certified to the credit reporting agencies the permissible purposes for which the report is being obtained, and certifies that the report will not be used for any other purpose. And the last one that I'll touch on is users must notify consumers when adverse actions happen. This is really key. The term adverse action is defined very broadly by Section 603. Adverse actions includes all business, credit, and employment actions affecting consumers that can be considered to have a negative impact as defined by Section 603K of the FCRA, such as denying or canceling credit or insurance, or denying employment or promotion. No adverse action occurs in a credit transaction where the creditor makes a counteroffer that is accepted by the consumer. Okay? So now that we didn't got through like the basis of how the credit report agencies work, what they explain when they talk about permissible purpose, let's now go to the definition according to the FCRA, according to the law, of what permissible purpose is. You want to find permissible purpose, you're going to look up 15 USC 1681B. Permissible purposes of consumer reports. And I really like this section because it's very clear English, plain and to the point. If you go to A, subject to subsection C, now when you hear that line, subject to subsection C, is basically saying that, okay, in part A, everything is acceptable, but you have to look at part C, and there may be some exceptions there, okay? Any consumer reporting agency may furnish a consumer report under the following circumstances and no other. Okay, the following circumstances and no other. Number one, in response to the order of a court having jurisdiction to issue such a order, a subpoena issued in connection with proceedings before a federal grand jury, or a subpoena issued in accordance with Section 5318 of Title 31. And number 2, this is the most important. If you haven't been taking notes, now is the time to take the notes. Number 2, in accordance with the written instruction of the consumer to whom it relates. So I'm going to piece that back together for you and give you the greatest understanding of how you can use permissible purpose to get anything off of your credit report. It says that a consumer reporting agency may furnish a consumer report under the following circumstances and no other. Number 2, in accordance with the written instructions of the consumer to whom it relates. So this applies to anything across the board, whether it be child support, whether it be student loans, whether it be from credit cards, no matter who it is. If it's a negative thing that's on your credit and you just don't like it, bro, you got to let them know, I never gave you guys written permission. And according to the law, you must have written permission. Okay? Now let's look at subsection C so that we can get the understanding of where this, the subject to or the exception will come from. Subsection C says, intends to use information in connection with the underwriting of insurance involving a consumer. That's it. So when you go to get insurance, yeah, they can go ahead and pull your credit. Permissible purpose is basically almost guaranteed. Okay, so now we're going to switch over to talk about why child support specifically should not be on your credit report. So for those who are like, well, Dev, I don't got child support, so I'm not really worried about that. It's not on my credit. I just want to know how to get it off of my credit. Well, I'm going to use this one in particular to explain how to get child support off of your credit, and then we're going to dive deeper into how to just get everything off of your credit. What are the steps of the things that you have to do? Okay, so if you go to 42 USC 666 7A and B, okay, that's very important. So when we go to 7, it says reporting arrearages to the credit report. 9 times out of 10, when child support is reporting to your credit, they are reporting the money that they say that you owe in arrears. Here's what the law says about it. And typically, if any of you have ever tried to challenge child support being on your credit, they might have sent you a response, and they included this section. They included 42 USC 666 section 7A, but they left out part B. So let's break it down. Procedures subject to safeguards pursuant to subparagraph B. Remember, subject to means this might be the exception. Procedures requiring the state to report periodically to the consumer reporting agencies as defined in section 16AF of Title 15, the name of any non-custodial parent who is delinquent in the payment of support, and the amount of overdue support owed by such parent. So this law is basically saying that they are allowed to put child support on your credit. However, it's subject to the safeguards. Okay, let's look at the safeguards. We're going to go now to section B. Safeguards. Procedures ensuring that in carrying out subparagraph A, information with respect to a non-custodial parent is reported only after such parent has been afforded all due process required under state law, including notice and a reasonable opportunity to contest the accuracy of such information. Do you see how important that is? Do you see how important that is? Due process must be met. So if child support is on your credit and due process hasn't been met because you haven't received a notice, you haven't had a reasonable opportunity to contest the accuracy, then it should not be on your credit report. Not to mention, there has not been any permissible purpose, because if you have not given them the authority, the permission to report these things to your credit, it has to come off. So now let's just go over the steps of how you can get these things off of your credit report. Now, when it comes down to disputing anything that's on your credit report, you must prepare what's called a dispute letter. And in this dispute letter, essentially what you're going to do is you're going to look over your credit report, okay? Whether it be with TransUnion, Equifax, or Experian, you'll look over these three reports. You'll see the negative item, whether it be an inquiry, a late payment, a collection, a charge-off, whatever it may be. You're going to write down that case number, or that account number rather. You're going to indicate in the letter that this particular item with this account number is reporting inaccurately to my credit report, and it must be removed according to the Fair Credit Reporting Act. You're going to also cite that I've never given you the permissible purpose to put this on the credit report. And then that's when you can list 15 USC 1681, which says that it can't be on a credit report unless I have given you my written authorization, my written permission. This is how you get things off of your credit report. And then you send it to those credit agencies. Now, essentially what the credit agencies will do is they will reach out to the furnisher, the person who put that particular negative item on your credit report, and they will verify if this information is accurate. Now, here's the catch-22 when it comes to that. Sometimes it can get deleted because they don't either get a response or they can't confirm if it's accurate or not. Most times the furnisher will just say that it's accurate, and then the credit agency will then respond back to you and say, hey, we reached out to Capital One. Capital One said your late payment is accurate, so they'll leave it on your credit report. However, you can therefore ask the credit agencies to demonstrate what proof they have to show that the information is accurate. Now, when you want to challenge the child support on your credit, this is very important. When you're challenging the child support on your credit, you are not going to write a dispute letter to TransUnion, Equifax, and Experian. Instead, what you're going to do is you're going to create a letter stating that they do not have permissible purpose. You're also going to state that according to 42 USC 6667 A and B, that they have not met the full criteria of providing you due process, because either you have not received a notice and or you have not been given the opportunity to test or contest the accuracy of this information being on your credit report. The reason that you want to send this directly to the child support agencies is because they are the ones who furnish the information. And then you let them know within that letter that you plan on filing a lawsuit against them if they do not adhere to your request with taking this off of your credit report, and you will file a lawsuit and you can sue them. And trust me, you can get paid a large amount of money for them violating not only your due process rights, but violating the right that you have according to the FCRA. So guys, I hope that this information was helpful. I hope that you're able to take this and run the play. Do what's necessary to get your credit clear and free, and also do what is necessary to get child support to come off of your credit. If you haven't already, man, I hope that by now you see, Dev Hot, he giving out game, he giving out all facts, he breaking it down in a way that I'm able to understand. And if I have done that, if I have met that standard for you, go ahead and hit that subscribe button. Definitely hit the like button so we can share this with more people, and leave a comment as into what more information you will want to know about this particular subject or any other subject as it relates to credit and as it relates to child support. With that being said, Dev Hawk, Title 4D University, your coach, your teacher, your professor. I'll see you on the other side.